Disputes, these happen everywhere, at home, at work, and the music industry is no different. In the digital era and with the rise in influence of social media, several scenarios arise that may result in disputes. For example, an artist may decide to share or start a challenge that uses another artist's music. What should you do? Do you fight? Do you resolve? At Lumallas Achieng Kavere Advocates, we have expertise in actual dispute resolution, mediation, arbitration, and if the worst comes to worst, the adversarial court system. Join me, Paulette, this week as we talk about dispute resolution.
So when you have a copyright, you can license anyone to make use of that right. Okay, licensing simply means that they have a right to do whatever you have authorized them to do under the license agreement without parting with the ownership of the particular right. Contracts are very important because they spell out what rights and obligations that parties have over your copyrights. And it's very important for you to read the fine print, because some people enter into such contracts thinking that they are going to have a copyright to the works that have been created. When you approach a publisher, what exactly are you looking for? A publisher simply finds uses for your music so that revenue can accrue to you, and then you can share that revenue with the publisher in the ratio that you will have agreed upon. This section is going to address those of you who are in bands. I have a question for you. Do you have a band agreement? What is a band agreement? How have you registered yourselves as a band? These are the questions that you need to ask yourselves way before you form the band or at the point when you're forming the band. It's very key to know, how are you going to market? Are you registering yourselves as a partnership, or are you registering yourselves as a limited liability company? Personal managers, as the name suggests, are basically there to manage you, to deal with your publicity and public relations, to advise you on your career development, to give you wise counsel when you're negotiating contracts before you enter into them. How do you pay your personal manager? You have to negotiate that in an agreement. But the standard practice is that you pay them a percentage of your gross earnings. Another category of contracts is a contract with your agent. Your agent simply finds gigs for you, and you share the revenue that he brings to you. The last category I want to talk about are business managers. These are people who handle your finances. For example, they make sure they file your taxes, they make sure your bills up, you have paid your bills, and you pay them not as a commission from your earnings, but an agreed fee or an hourly rate.
Yes, music is a business. It's actually interesting, Kavere, that you talk about perpetuity, because Mutuku Mudhama is asking, are there some terms or words, for example, perpetuity, that people should be aware of when signing contracts in the music business?
Yes, in fact, if you see the word perpetuity, if you do not have a lawyer and you just see perpetuity, just circle it and ask that it be removed from the agreement, unless you really, perpetuity simply means forever. And I don't think we are able to determine forever positions in the present. So it is good to give room to extend, but not give an outright right ab initio. Ab initio is from the beginning, from the onset. Do not give away your rights in perpetuity from the onset. Be in the habit of giving timelines and giving room to extend. If things are rosy, then you can always come back to the drawing board and extend the term of the agreement.
Hi everyone, welcome to our webinar series this week. we've been talking about the legal challenges of artists in the digital era. Previously, my colleagues went through the need for signing of contracts, even with the case study of Mpumi, and the ownership rights that artists have in their music. Today, we are going to talk about dispute resolution. Inevitably, with the digitization era, there's been ease of reproduction of music. There's been the social media influence where people can easily use your music to influence followers. And there have also been challenges with the laws and the contracts that people enter into. Even with a good contract, there can be still some disputes, and that's why a good contract has a dispute resolution clause. When we talk about disputes, some of the possible disputes that have been recorded in recent times are artists breaching the contracts with their record labels or with their producers, or in band management agreements. There could also be breach of contract. There could also be another area of dispute resolution is in copyright infringements. For me or C4, her producer decides to record her music and earn rights or register a copyright in Fumi's work without her consent. So even as we see such possible disputes, it is on a good note that we say that not all disputes need to go to court. Most of these disputes have come to the public light and hence have given most of the artists a bad reputation. As an artist, I would like to be able to resolve my disputes first in an efficient way without necessarily attracting bad press, and also in a timely and cost-effective way. So how do I do that as an artist? While ADR to musicians is automated dialogue replacement, in dispute resolution, ADR actually means alternative dispute resolution. An alternative to what, you may be thinking? An alternative to litigation, an alternative to the court system, an alternative to solving disputes in an adversarial way. ADR simply means an alternative dispute resolution method that leaves us as friends even while we resolve our disputes. It doesn't sever the relationship of the parties. You may wonder, what are the forms of ADR that are available to me as an artist? I'll start with the most common form, which is mediation. And mediation simply means bringing in a neutral third party so that this person can hear our side, both of the sides of the story or the dispute, and try to get us to reach a settlement that doesn't involve a judicial. A mediator doesn't make an award. What a mediator does is comes up with a sort of compromise between the parties, and it is actually a party-led dispute resolution method. The difference between ADR and arbitration is that in arbitration, a neutral third party actually adjudicates the dispute. He sits like a judge, obviously not in the court process, but he decides. He hears the parties and decides what will be the final award that he will be giving. So as artists, the challenge therefore for us is to look for ways of resolving disputes at any point of the contract. It could be at the negotiation stage. And before leaving a band, if we could just put our egos and our differences aside for a while and work towards every party winning. Because when there's a dispute, nobody is making money out of the music. Another food for thought is also that maybe artists can also train as mediators and as arbitrators and get into bodies, lobby for bodies that are driven by artists to be the dispute resolution bodies. They are then comfortable to have the expertise to handle their disputes and people who are knowledgeable in the music industry, so to speak. Lastly, we have to think of maybe some of the disputes do not need to get to the dispute point if we actually get into agreements beforehand. For example, when a band member leaves, if you have a partnership agreement or some sort of band management agreement, then this would already forestall disputes on what happens to the copyright we have accumulated before, who has the rights to the band name, who actually what happens to the music that will be produced after the band member leaves, and does the leaving band member get a payout? And all this can be easily resolved through a partnership agreement and other forms of contracts that the parties can get into. Thank you very much. Welcome to our webinar, and next week we'll be talking about data privacy and protection.
So when people disagree, and thanks Paulette for taking us through that, one of the things I am very certain that I have had many of my artist friends say, lazima nitamsuu, nitaenda kotini sai, I have to go to court because he's messing with me. So some of the questions, keep the questions coming, but one of the first questions I wanted to ask, what's the difference between when you go to a mediator and when you go to an arbitrator? What are the expectations as an artist if I'm sitting with a mediator?
Thank you, Karimi. We spoke about that, and if you watched the trailer, we were saying the difference between arbitration and mediation is more party driven. So when you go to a mediator, you're not looking at the mediator as a judge or somebody who will make an award. He'll basically facilitate the discussion. Mm-hmm. So the mediator puts into writing what the parties have agreed, as opposed to arbitration, where the arbitrator sits as a neutral third party, and he sits kind of like a judge, because at the end of the day, he's the one who will make the decision as to who is right or wrong. Mm-hmm. Yeah. So when you go to mediation, you need to go with the open mind that it is a win-win situation, and it is what the parties want in the agreement that will end up in the agreement.
So you have to have the heart to agree when you're going to a mediator.
Yes, definitely, because that's what we are saying about dispute resolution. We are saying before you think of niende kotini, fixing the guy, can we sit and talk?
Yeah, because talking really does move forward. And some of the, I think I said it in the copyright conversation, that you really, the creation process has to have that nice energy around it. So if you don't have that nice energy, so what would you advise if you're sitting as a licensed mediator, arbitrator? What would your advice for an artist be, where mediation and arbitration is concerned, knowing what the artist process is?
Obviously, you want to save on costs, you want to save on time, and you want to keep the relationship flowing. So I would always start a good dispute resolution clause. Thankfully, Kavere had taken us through the contract webinar last week. So one of the key things in a good contract is a dispute resolution clause. So in that clause, I would be advising a client, first start with negotiating between the parties. If you can't reach an agreement between the two of you, then you can involve a mediator for starters, because mediators then just facilitate the discussion.
Yes.
Then if that fails, I would go into arbitration. But there's also processes of mediation, arbitration. It can be a mix.
It can be a mix of those two.
Yes.
Because I just want to make it more practical. And I think there's I'm sure the artists who are watching and creators who are watching have had situations where, somebody has done something. I think just recently at least actually every week or so we hear of, someone used my song for a campaign. I think it actually happened maybe in the last campaign. Someone's picture was used in a campaign probably the other election, but see things like that. So what are the steps somebody can take? Because sometimes you're sitting somewhere, you don't even have an agreement with someone, but you want to resolve the thing quickly and as you said, it is efficient, but you want to resolve it quickly. How do you get to that space? Because you've said we want to start with negotiation, of course. How do you get to that place?
And that's a good question, Karimi, because sometimes it just takes a call. Just call the person and let them know, by the way, I have taken note of you using my music. This is wrong for this reason. Can we sit down and talk? Sometimes it just starts with a phone call, as opposed to sending threatening messages or something. Just start with a phone call. If the phone call doesn't work, then seek legal advice, because then that is where the lawyers come in. We start with a demand letter and just tell you, we made a phone call, this has not changed. Then what are the legal repercussions, and could we have a meeting even? Because most lawyers are also mediators and they're also arbitrators. So that's a good space for someone to advise you on what are my dispute resolution options right now. Because if I've made the phone call and it's not being heeded, and probably I've done a demand letter, then maybe then we can go to the next step of, now let us appoint a mediator. These are the people that I have in mind. Do you have other people in mind? Let us sit together and see whether we can talk about this. Because lawyers don't always come with threats. They also, unlike what most people think, they also come, they want you to get a solution. And in such a situation, if someone is using your music, I think of it as free marketing as well.
Yeah, but and I understand the angst that people have. But in fact, there's a question from Immaculate Were, and she's asking, what assurance do I have as an artist that ADR won't just waste my time and I'll just end up in court? Because another thing that you're looking at is how do you know how that this is a process that will bear fruit? I think that's the question.
I think it starts with the thought about who is going to be an appropriate mediator. Because if you just choose anybody on the street who probably doesn't even understand what are the rights involved, what is involved, then you might end up in the wrong process that then wastes your time. So my advice would be, pick a good lawyer, a lawyer who's been in the entertainment industry for long enough, someone you can vouch for their experience. Yeah. Let them assist you getting the best mediators that they think could resolve the dispute, and then that way you can be assured that you're just not wasting your time. Because mediation also depends on the expertise of the mediator, and there are certain biases as well that come with even appointing a mediator and stuff, because you also have to look at who is the appointing authority of this mediator. Is this mediator somebody who works more with producers or with artists? What kind of person am I choosing to sit over my dispute? Because
what kind of doctor are you going to?
Exactly. You just hit the nail on the head. Yes. Because you're not going to go to a surgeon for a toothache. You're going to choose a dentist.
That's good. And she has a follow-up question for what is more costly, ADR or litigation? I mean, approximate figures really depend on what the process is. But yeah, I think that's a good point, because ADR, when we were studying, it was really flouted as it was said to be the easier way to deal with things. But I think even as you're answering the question about what's more costly, let's talk even about time in ADR and time in litigation.
And I think time is money. I mean, everybody knows that time translates to money at the end of the day. The time you'd be wasting in court, because how long does a court case take to resolve? So for me, I would think of ADR as an inflexible process that a good mediation session really should not take more than 3 or 4 sessions, because the first session is to get to know the parties, and then you get to caucus with the parties. And honestly, in a good 3 or 4 hours, depending on the dispute, obviously I'm not giving fixed timelines, you should be able to know as a mediator, is this something that is going to be resolved by mediation, or at least by the second or the third session, you should be very clear that this dispute is either not going to be solved by mediation, or it's going to be solved by mediation. So definitely for me then, the mediation would be the way to go.
Yeah.
If it's also depending on the weight of the issue as well.
Yes.
Yeah,
Yes.
and also remember that these are voluntary processes, so
Yes.
also requires goodwill of the parties.
Exactly.
Yeah,
Exactly.
so if you go in with a mind of I need to fix this guy, or your own ego, then you might fail to see the gains for what they are, because you even if the mediation doesn't completely resolve your issue, you can walk away with one or two agreements. You can
Yes.
partially solve a dispute and leave whatever cannot be resolved for court, so that that mediation agreement can even work as a consent judgment if the matter was already in court.
In court.
Yes.
In fact, that was a question just now. Can court compel someone to go to mediation instead? I think, and let me ask all the questions. Can court compel someone to go to mediation instead? Where are the mediators found? Are they lawyers? Some of them are. What is the process of finding a mediator? And maybe you can just touch a bit on the judiciary process in bringing mediation as one of the ways of moving cases forward.
Actually, that's a good question, because this week is actually one of the weeks that the courts are actually emphasizing on mediation, and there's court-annexed mediation. And yes, the court cannot force you. I think the words that were used were forced, because mediation is a voluntary process. But as a party, you'd be viewed differently if you refused once it's offered. So I would suggest that the person takes the offer of mediation, because for one, the court-annexed mediation, at least in Kenya, is a cheaper process.
Yes.
Yes, because the courts take on the cost of the mediator for you. So I don't understand. It would be. I used to be told by my primary school teacher that never refuse a good offer. So I would say don't refuse that good offer, because you might just surprise yourself and save on costs and have the dispute resolved, if not fully, at least partially.
Partially.
Yeah.
So are you then saying we say our issue is money and my feelings? So
Yes.
we can deal with my feelings at mediation and deal with money at the court process. No, just giving an example.
Okay, Karim. The thing is, the courts will also be bound by the law. So you see, if the law covers feelings, yes. But if the law doesn't cover feelings, don't expect the mediator to cover things that the law will not cover.
So let me give an example. So I
Yeah.
was in a band,
Yeah.
and we are in this band with Kavere and Paulette and myself, and then you guys kicked me out because you just didn't like the dress I wore that day. So can I then go and be upset? I mean, have a mediator now, figure out what our songs will be and what cut I get of what your future work is going to be, because you see, that would be my dispute that I would be bringing to the mediator. But if the mediator is dealing with maybe future work, maybe saying that you'll be riding on the name that was us as a group, maybe I want you guys to pay me for even future work, something like that.
Okay, I wouldn't consider really future work, but I would say yes, to the extent that the mediator tries to get to where the parties are, because sometimes a dispute is brought because, like you said, feelings. Sometimes somebody just wants an apology.
Yes.
And it would be so easy for you to give that apology and resolve that dispute. So that's why mediators are trained even on how to have the conversation going, how to rephrase the state so that you're managing feelings, because disputes really is about feelings. We might laugh about it, but it truly is sometimes about how you manage people's feelings.
Yes.
There's usually also a power play. How are you managing that power play? Somebody feels that they're more superior. So yes and no to the future, because then when you're coming to a mediator, you already have a case in mind. So about the future agreements, that would be more about negotiating and having another contract for that.
Okay.
But the mediator would try and resolve the present dispute, what is bringing you here now.
The mediation process feels to me like a very feel-good place if the two parties are together, because Felix Kimanthi was asking about who decides, and I think when you're what I'm getting from you is when you're open to actually getting the process forward,
Yes.
then mediation will really work for you if you want to resolve the dispute.
Yes.
But if you're already in a space where you already want to go to court no matter what happens, then mediation won't work for you.
And remember what we have been saying all through, and we'll repeat, is that mediation is voluntary.
Yes.
So nobody can force you to go for mediation. If you feel that it won't work, nobody will go. But like I said, never refuse a good offer, because you might be surprised. You might even get a better deal than what court might give you by just agreeing as the parties.
So,
and you see, mediation doesn't have rigid rules of procedure.
Okay.
So you can just agree in a short while, this is what I want. The other party says, this is what I want. If we can't meet in the middle, what is the best compromise for everybody? Everybody walks away with a win-win situation.
So that's mediation. So taking us to arbitration, and my arbitrator has written an award.
Yes.
And I'm upset at this arbitrator's award. Where is there a possibility of going further into court if that's what you want to do?
Well, it would also depend on your contract, because if the contract provided for dispute resolution by arbitration,
Yes.
then unfortunately you might not in all instances be able to appeal to court. There are specific instances that you may be able to appeal to court, but not all. So you also have to be careful how you're drafting your
arbitration
dispute resolution clause, so that if you want the option of going to court, then your lawyer will advise you this is the best way to draft it. If you want the option of just saving money, having the arbitrator's award as the final award, and you normally say it's the final award, then you need to be aware that the process of appeal will not be available in the event that you don't agree with the dispute with the award given by the arbitrator.
So it's a contractual issue.
Yes, and that's why you always need a good lawyer to guide you depending on what you want. Yes.
Wow. One of the things I've heard a lot from disputes around our space is when like you said, you go to a dentist if you have a toothache. One of the questions Felix Kimanthi was asking was about CMOs and royalties, and I covered that in the first session. But I think there's new corporate amendments that have been made, and what they've tried to put that, and I highlighted that in that session. But they are looking at regulating the CMOs in a certain way. If you go to the Kenya law website, you can download the corporate regulations, new amendments, and I think they're 2020, and you can see some of the things that they have put in place for regulation of CMOs, because a lot of people have been talking about royalties and things like that. But if you go back to the CMO, the copyright session, you'll get those questions answered. That's to Felix. There's another question about mediation settlements being acceptable by court if they are not court initiated. Can a court overrule something that you agreed upon in mediation? Because the one thing that is certain that people change their minds. So you and I agree, then I go back and I sleep on it and I say, okay, the mediator came up with this thing, but I'm not happy with it, and I go straight to court. Can the court just set aside? I think that would be the word. Can they set aside a mediation agreement that you come up with?
Again, Karimi, that would depend on how it's drafted. If there is liberty to apply, usually that's a clause that is put in agreements. Then you have liberty to apply to the court to review, set aside, vary. But if there is no liberty to apply, you see, and I don't see why a court would uphold something that the parties actually sat down and agreed, unless it's an illegality, or there really must be compelling reasons why you have changed your mind, really, because you sat and you agreed.
And you
Yeah, and
agreed.
you shouldn't waste people's time.
Yeah.
By,
It's an abuse of the court
yes,
process.
it's an
really.
abuse. It's
Yeah.
an abuse.
And you really should be going to court to spend time and court's time and your own time in things that are going to change outcomes and be beneficial to both parties.
Exactly. Unless there's an outright injustice, I wouldn't see the courts really overturning. And I'm wondering at whose instance. Is it the same party that sat and agreed,
So imagine, because this is a scenario that can happen all the time. So we mediate and we agree and we say we are going to do 50-50. But I know that I have a deal that is coming that is X amount of money. So I wait for us to mediate, and then I go get paid lots more money than we had yes. Agreed. Because people do that. I mean, it's cloak and dagger kind of behavior, which is consistent. There are good people and there are bad people.
And that's why I'm glad Kavere talked about last week.
Yeah.
Put it in writing.
Yeah,
put it in writing. Don't also say we had a mediation agreement and it wasn't in writing, because then that agreement can serve as a contract to set what did the parties agree.
Yes.
And the courts would very reluctantly go against what did the parties have in mind, because that's a contract. Because
other scenarios that I have found that happen is when we're in studio, which I was talking about, when people are in studio, we are vibing and we are good and we are all friends, and then something happens and somebody walks out or walks away, and a lot of times people want to, the bad guy will want to come and take the whole bag and walk away and leave everybody else hanging. And those, even when you're sitting with a bad guy, when I teach my contract classes, I always say a contract is only as good as the person who's signing it. So even if you have those contracts, we've done all the elements and we know that they're there, you have put a good mediation, an entire ADR clause, but the person is a bad guy and will walk away with whatever. Would you advise that kind of, when you're dealing with that kind of person, is court your best option? Or is I guess you have, and if you have that arbitration clause, maybe then what's your advice? Because if a guy is just gonna be off, what do you do?
Still, like I said, you've put it in writing, and now a dispute presents itself. Just try the process that we've said. Call the person and say this was agreed.
Yeah.
And it's in breach. If they're still in breach, do a demand letter. If that isn't working, then you can try other, like you say, either mediation, arbitration. Court should be really a last resort. But if it's in writing already, and it would just depend on the actual circumstances, because I'm imagining that you don't want also to spend a lot of time resolving something that is already written. And I would prefer an arbitrator in that
space.
Yeah.
I want to put just perspective. I mean, you litigate, and in commercial matters, and commercial matters meaning things to do with money.
Yeah.
What are realistic times from the beginning of a court case? Now, specifically court case where a dispute has happened. Realistic timelines, assuming, and this we are assuming that both parties are ready and pre-trial, everything has been done. Realistic from beginning to the end for a court matter to begin and be heard.
I don't know, we are talking about COVID even right now. You just know, even with technology, sometimes technology fails. You're in the middle of a court matter, the magistrate disappears, or even the court closes because of COVID. Really, timelines we can't. I wouldn't stick myself to timelines, but I would give you 5 years. But we're talking years.
Yes, we are talking years.
I would give you even 5 years.
So if I start a case now, we're in 2020, best case scenario, it will end in 2023. Best case scenario.
I can't say best case, because also it depends on the magistrate handling the matter, or the judicial officer, the judge, whoever is sitting in. Because there's some magistrates, to be fair, who are also very proactive, and they will handle the matter expeditiously. But I can tell you, the thing with court is that there's so many variables, like we are saying. There are delays caused by the other party. There's your own circumstances. Life happens. Sometimes on the day of court, you're not able to appear, or you're unwell, or some. I mean, life happens. So there's so many variables that are not in your control, as opposed to a mediation or arbitration session where I can call the magistrate and they'll. I can call the mediator and they'll not tell me about the court diary.
Court diary.
Yeah, they'll not tell me about
COVID is closed.
Yeah,
COVID closure.
because you can meet at any place of your convenience. Obviously, a good mediator or arbitrator would know what are the neutral locations to go to, but it doesn't have to be so rigid. So in that way, then you save a lot of time and expenses.
So I hope for Immaculate and Felix, you've gotten that. Lily is asking a question about singing a translation of a song, and I covered that in the copyright space. And translations of songs are adaptations of a work. So when you create someone's work, and the example I gave was the song Adele wrote. Was it Hello? It was Hello. And one of our Kenyan artists did a Kiswahili translation. I think they got permission for that. But yes, you do need to get permission for any adaptation of any work. But if you go back to the copyright webinar, you'll be able to. And there's a link in the Lumallas Advocates space for you to get that. So the other question is, where copyright is concerned, how often do conflicts of this nature arise? Can they be resolved by mediation?
Karimi, I think we've talked about any kind of conflict can be resolved by mediation if you choose and if the parties have goodwill for that. But I think you're even better placed to talk about the mediation process that is adopted by the copyright associations as well, given that you spoke about copyright. I'm sure they do adopt mediation as a starting point.
Yeah, and I agree with that. Just keep the questions coming. We have another 10 minutes before we have to close. But yes, when you were talking about contract and what you said about there being a need for that arbitration clause, what if I don't have an arbitration clause? What an ADR clause? So where I've not talked about mediation, I've not talked about arbitration. So what do I do? Because my contract did not have that. Because you see, I mean, those cases do happen. A lot of people do write contracts that don't have those clauses.
I think if there's anything you'll get away from this webinar is please hire a good lawyer, because there's no lawyer who will draw up a contract without a dispute resolution clause. But if you find yourself in that unfortunate situation, it's no bar to say that because we didn't have a dispute resolution clause, we can't go to mediation or arbitration, because you're still, I mean, it's open as to how you deal with the dispute. You actually didn't say. So I would still say that you can still choose whichever type of dispute resolution mechanism you want.
Yeah.
But that is why it's important to always seek legal advice from a good attorney or lawyer, because then they will advise you on such things. Because even the choice of dispute resolution, the dispute resolution method can be a source of conflict.
Please expound.
Because
yes,
if we possibly are, say, I've seen some countries where there's there are arbitration bodies for artists.
Yes.
Yeah. So you see, if I, as the artist or the producer, are agreeing, we can agree that will be the organization that will appoint for us a mediator.
Yes.
Because there are very many, you see, like the law societies, they can be an appointing body. So it's important when you're drafting that clause so that you are not also starting from a point where now, who is going to resolve our dispute? Because then you can decide if it's a lawyer that you want to handle. I had somebody ask whether are all the mediators lawyers. Not they don't necessarily have to be lawyers, but you see what kind of expertise are you bringing to the table. So that is what that would be what would guide you as
Yes.
you're doing the clause, so that you know, what do I want, which body, and it also avoids some biases.
Yes.
Yes.
And also some biases in terms of who the person who's mediating or arbitrating, they may have the knowledge, and but they need to also be removed enough for them to be able to be impartial.
Exactly. And also structural biases that come from what is the dispute resolution mechanism that we are choosing, because even in mediation we can decide to have 2 or 3 mediators. It doesn't have to be a single mediator.
It doesn't have to be a single mediator.
Yeah,
And
because then I've had somebody ask, how if the mediator is biased, what do I do? Remember that the mediator is a person.
Yes.
So how do we mitigate against that bias? Probably by having 2, one chosen by you, one chosen by me, and one by a neutral party.
I see.
So that deals with the structural kind of biases that we are talking about.
So you create a bench, in other words, so that everybody's part is sort of hard. But a good mediator also should be able to remove themselves from the matter and decide and guide, because a mediator guides, but an arbitrator decides.
Exactly.
Yeah.
Exactly. I like the way you've put it.
Yeah. Okay, Lily, I think those questions have just been answered. She was asking about impartiality maintained in mediation. Is it guaranteed? If yes, how? And she's just given that.
But also, just to add, you see, a good mediator, the reason you're choosing even a good mediator is that they've been trained.
Yes.
And part of the training, I'm a mediator myself, part of the training is how to be just aware of bias. And even you as the disputant, we call the people bringing the matter as the disputant, you can engage on, there's what we call immediacy. I'm also a counselor, so I might use some counseling terms that may not be legal, but there's a quality of immediacy. Just point it out.
Yes.
And then in that awareness, the mediator will be able to just be aware that they're exhibiting a bias, and from their training they'll be able to realize that because some biases are personal.
Yes, agreed.
So just
people are human beings.
We are human.
I see some questions from copyright and some questions from contract. I mean, we're talking about mediation and arbitration today, alternative dispute resolution. But the question on copyright, Sylvia, just go back and watch the copyright webinar, and there's a contract one after that, and today was that. So I'm gonna give you the closing remarks today, because I think, thank you again so much for being so concise and very in the way that you presented arbitration. Now I just want to have everything arbitrated. What are we going to eat today? Let's mediate.
Let's have a negotiation
about I'm feeling like plantain. What are you feeling like?
Exactly. And that's what life is about. It's about give and take.
Yes. Yeah. And for sure, because we don't always have to have the whole of it. I think that analogy for that Solomon story for cutting
you don't have to cut the baby into half.
You don't have to cut the baby into half.
That's not equity.
We are here for the money, and we really want to get along so that we can create more. Thank you guys for joining, and we'll replay the presentation of the episode for those who missed it immediately. So you can hang on and watch the episode. For those, again, who are not able, tell your friends to just log on and watch the shows. And now there's 3 episodes, and there's 2 more exciting ones to come. But now you can watch the 3 episodes that have already aired from the LAC YouTube channel. Follow the LAC socials, LAC Advocates _KE on IG, Lumallas Achieng Kavere Advocates on Facebook, and feel free to DM or email your questions for this one or anything else, and we'll take us as short time as possible to answer. And next week the session is on data protection with Josiah Mugambi, yes. So, and I'll be joining you the week after that with digital matters, but we'll talk soon. And I enjoy your week, and please watch all the episodes and send us the questions.
See you next week. Kama kawa, kama dawa.